Purdue Pharma agreed to a $7.4 billion settlement, but the Supreme Court rejected the Sacklers' escape plan first. The mechanism was bankruptcy engineering, a non-consensual shield that would wipe opioid lawsuits against the family forever, even though they never filed bankruptcy themselves. In June 2024, the court ruled the bankruptcy code does not authorize that kind of blanket release for non-debtors. The replacement deal requires up to $6.5 billion from the Sacklers over 15 years, plus approximately $900 million from Purdue, voluntary opt-in releases, not the shield the court struck down. How did a family-owned pharmaceutical company reach this breaking point, and what does the fallout teach about corporate accountability? Purdue Pharma was a privately held drug maker owned and controlled by the Sackler family. In the mid-1990s, it began marketing OxyContin, an extended-release prescription opioid. The product generated billions of dollars in sales and made Purdue the center of the family's pharmaceutical business. The commercial promise was simple. Purdue presented OxyContin as less addictive and less prone to abuse than other pain medications. That claim eventually became part of the legal record. In 2007, one Purdue affiliate pleaded guilty to a federal felony for misbranding OxyContin as a less addictive, less abusable alternative. Thousands of lawsuits followed. Patients, families, states, cities, and other governments alleged that Purdue's marketing had understated the drug's risks and helped expand its use. That sequence matters. The product claim created the revenue, the guilty plea established a legal breach, and the lawsuits converted that breach into a threat to the company's accumulated value. The guilty plea did not end the business. Purdue continued operating while litigation risk moved closer to the company and its owners. What began as a product strategy was becoming a balance sheet threat. The next question was no longer how large OxyContin could grow. It was how much value the owners could move before the claims reached them. After the 2007 guilty plea, the financial strategy changed. The Supreme Court's account says Purdue's distributions to the Sacklers had previously represented less than 15% of annual revenue. After the plea, the family began taking as much as 70% in some years. Between 2008 and 2016, those distributions totaled approximately $11 billion. The court described that amount as roughly three-quarters of Purdue's assets. Much of the money moved to overseas trusts and family-owned companies, while the drug maker faced a growing wave of opioid litigation. The withdrawals did not end Purdue's operations, but they changed the company's resilience. A business confronting thousands of claims was also sending a large share of its value to its owners. By the time Purdue filed for Chapter 11 in 2019, the company was financially weakened, and the Sackler distributions had become central to the bankruptcy fight. That tension set up the next move. Purdue entered bankruptcy, but the Sacklers did not. The reorganization would therefore have to answer a difficult question. Could the company's bankruptcy protect owners who had never filed for bankruptcy themselves? The wave of litigation finally broke the corporate structure. In 2019, facing thousands of lawsuits from states, cities, and individuals, Purdue Pharma filed for Chapter 11 bankruptcy. But this was not surrender. It was a calculated legal gambit designed for one purpose: to build a firewall around the Sackler fortune. Buried within the reorganization plan was a radical provision, a non-consensual liability shield. It would use the court's power to extinguish all opioid-related lawsuits against the Sacklers themselves. Forever. It was the legal equivalent of a panic room, built not for the company, but for its owners. The plan moved through the courts for years, a battlefield where victims fought to have their rights recognized. The core question was stark. Could a bankruptcy proceeding legally force people to give up their claims against individuals who never went bankrupt? The U.S. government itself stepped in, arguing the arrangement was an abuse of the system. The case escalated all the way to the Supreme Court. The Sacklers' long-sought immunity now rested on a single judicial decision. In June 2024, the court delivered its verdict. The shield was rejected. The justices ruled the bankruptcy code does not permit plans that grant non-consensual releases to non-debtors like the Sackler family. Decades of legal engineering, a final masterstroke of corporate insulation, had just been struck down. The architecture for their permanent global peace was shattered. The family was exposed again. The entire settlement framework, meticulously assembled, collapsed. The shield was shattered. With non-consensual releases off the table, both sides had to negotiate an entirely different structure, one built on voluntary opt-in releases. With the liability shield rejected, a new deal took shape. On May 1, 2026, Purdue Pharma shut down and ceased operations. In its place, Purdue Pharma began operating a public benefit corporation owned entirely by the nonprofit Purdue Foundation, with no Sackler family involvement. The settlement totals $7.4 billion, up to $6.5 billion from the Sackler family over 15 years, plus approximately $900 million from Purdue. Purdue Pharma is overseen by independent directors and trustees. Under a court-ordered injunction, it is barred from marketing its opioid products, from lobbying, and from tying employee compensation to opioid sales metrics. The company may manufacture medications, including opioids, under strict oversight. The ledger names a price. The question for regulators and corporate boards is whether that price changes how the next corporation calculates risk. The final lesson of Purdue Pharma isn't about a pill, it's about a playbook and the limits of bankruptcy design. The Sacklers' last strategic move was to use bankruptcy court to shield non-debtor owners from liability. In June 2024, the Supreme Court rejected that approach. The Bankruptcy Code does not authorize non-consensual releases and injunctions that discharge claims against third parties who never filed for bankruptcy themselves. The replacement deal is structurally different. It totals $7.4 billion, up to $6.5 billion from the Sacklers over 15 years, plus approximately $900 million from Purdue. Rather than a blanket non-consensual shield, the new plan relies on voluntary opt-in releases. Claimants who choose to participate give up future claims in exchange for payments. That is not the same mechanism the court struck down. The family had already withdrawn approximately $11 billion from the company between 2008 and 2016, according to the Supreme Court's account. The dissolution of Purdue and the creation of Purdue Pharma, a public benefit entity with no Sackler involvement, restructures operations but does not erase the history that preceded it. The question that remains for regulators and corporate boards is whether this resolution creates a genuine deterrent, or whether bankruptcy courts remain a forum where wealthy owners can test the outer limits of financial engineering.